Good
I'm sorry,
evening.
my mic was not on.
Good evening, Deputy Chief Justice.
We are so sorry for keeping you on tenterhooks all day, but it's just impossible to control these proceedings, you know?
I fully understand. It
Yeah.
seems to be almost a rite of passage to come here and wait.
Yeah,
It's what you've
happened
got to go
me
through.
many times.
It's not a problem, really.
All right. You hold 2 degrees, a BUris and LLB from UP and UNISA,
That's correct?
and you started working as a lawyer in 1991. No?
No,
That was with the Department of Trade and Industry.
that's correct. As an
As an
assistant
assistant,
admin clerk.
what did you do there?
Deputy Chief Justice, I was an assistant administrative assistant, and I was involved in objections to company names. In those days, and I'm talking that's many, many years ago, in terms of Section 45 of the Old Companies Act and Section 20 of the old or the current Closed Corporations Act, entities could lodge objections against company names or closed corporation names or trading names and I was the person that had to deal with those objections, consider them, make recommendations, and either uphold or dismiss the objections.
All right. There's a bit of adjudication they say no experience is a waste.
No, that wasn't the waste, definitely
Yeah.
not.
So you started your legal career as a public prosecutor
Yes, that's
in
correct.
1993. And you were there until 1999?
I was there, I resigned, I think in January 99. I started with pupillage on the 1st of February 99, that's correct.
And thereafter you joined the society, the KZN Society of Advocates.
Yeah, I started practicing on the 1st of July 1999. It feels like a lifetime ago.
Yeah, that was a long time ago. And that's where you've been until now.
Yes,
You've had acting stints as a judge in the KZN division, not so?
yes, that's
A
correct.
number of them I see.
Yes, not counting this last week where I started with a new session on Monday, I've calculated it as 64 weeks.
Ah, that's a long time. Before I ask you a little bit about that experience, what kind of practice did you have? What kind of practice do you have?
Deputy Chief Justice, I think last time when the Chief Justice asked me that same question, I referred to it as a generalist practice where you do a bit of everything. You know, when you start out practice, you do whatever you get briefed to do. And I've done obviously a lot of family law work. That's just the nature of being a woman. You get approached to do those types of matters. A lot of delictual work, third-party RAF matters. Pietermaritzburg is a small bar, so you basically get to you become a jack of all trades. I've done cases involving cattle leases, fire cases, bank work, commercial work. It's really a mixed bag of everything.
Have you been able to produce written judgments as an acting judge?
Deputy Chief Justice, I've calculated that over the period that I've acted, I've written 67 judgments. 16 of them were extempore. Of the 67, 16 were extempore. My maths are leaving me now about how many are formally written judgment. But yes, I've produced quite a number of them over the last 3 years.
All right. Were you able to produce all of them within the requisite time, promptly, that is?
I try and do it as promptly as possible. Some of them I've been able to deliver. I think in the last session I dealt with a special urgent application on the Friday, and I gave judgment on the Monday. There's some of them that I can produce within 2 weeks. Some of them took me just under 3 months, and unfortunately there's 1 or 2 that took me just under 4 months to produce. But those were quite complicated matters and involved a lot of research. Yeah. But I will stay up till the early hours of the morning if it means getting something out when it has to go out. So, and I've shown that I can work under pressure to produce judgments if I need to do it quickly.
All right. Do you have any reserved judgments? Well,
No.
old one, that is.
No, I don't.
Okay. I see that all the law bodies that have sent in comments about you approve your candidature.
It must say it's pretty nice to read through their comments. I'm very appreciative and I'm very grateful for their comments.
Yes.
It really means a lot to be recognized by them.
Thank you, Advocate. DJP Madondo, do you have questions for this candidate?
Thank you, DCJ. Ms. Bezuidenhout, while we have been together, I can say good afternoon once again when I'm sitting here.
Well, we've been together almost all day,
Yeah.
so yes.
Am I correct to say, should you be appointed, you will be the first white female judge on the KZN Pietermaritzburg bench?
Yes. And I'll also be the first female advocate from the Pietermaritzburg bar to get appointed to the Pietermaritzburg bench. It's never happened before.
Yes. Would you say, well, obviously, would you say your appointment will enhance diversity on the bench?
I think so, yes. Definitely.
Are you supportive of the transformation of the legal profession? If the answer is in affirmative, why are you?
Judge, I'm definitely supportive, and I think if one looks at what I've set out in my questionnaire and also in what is contained in the reports by the GCB and OFT, and I think maybe Nadal as well, I've been involved in the bar structures for for many, many years, and I've been on the pupillage committee since 2016. And I pride myself on the fact that I was actively involved every year when it came to interviewing aspirant pupils for the pupillage program the next year to insist and to make sure that there are especially black female candidates approved and given an opportunity to do pupillage. Apart from that, I tutored or lectured civil trials. I'm a strong believer in the transference of skills. I've got an open door policy. The pupils that I taught during my times when I was teaching them civil trials, up until, well, not physically today, but currently they seek my advice. I sometimes get WhatsApp messages late in the evening asking for a quick question when they've got a brief or motion court the next day. And I just believe on continuing trying to transfer the knowledge I have. It's my duty. It's why we're in the profession. It's one of those professions where, although you basically training someone who could one day be your opposition or even take work away from you, you still feel obliged to make sure that you develop advocates and develop people that can become competent and a force to be reckoned of with when they appear in court against you. And even now, when I appear in court as a judge, I see them appear in front of me, and it's an amazing feeling to see young advocates that 2 or 3 years ago I was lecturing appearing in front of me, and you can see they're really making progress. And there's more and more of them. Even a month ago, one of the judges in our division commented and said it's quite amazing to see how many young black female advocates are suddenly appearing in court, and it's because it's now we're seeing the fruits of selecting young female black advocates to do pupillage and start their practice, and they're starting to now appear in court, and they're doing very well, and it's amazing to see the progress that's being made.
Well, those who have commented, they say you frequently assist indigent litigants. Can you share with this commission what type of assistance you offer to them?
Well, the assistance, I obviously do my share of, or in the past did my share of pro bono work, but when it comes to indigent litigants, especially in matters the delictual matters against the Road Accident Fund, against the Minister of Police, those types of cases, you're sometimes dealing with the poorest of the poor, someone that got arrested in a rural area and locked up for 5 or 6 months, and you've got to go to court, and they can't afford to brief counsel. And I've always made arrangements with the attorneys that I will, at the end, at the completion of the case, only charge whatever is allowed on taxation. I've never signed a contingency fee agreement. I'm not impressed with these performance fees or whatever. I don't even know how it works because I'm not interested in it, where you now take money out of the capital of a person that's successful. I think they call it a success fee or whatever. I just never entered into any of those types of agreements because I don't want to take any of the capital away of the indigent person. And I've quite often been approached by attorneys to say, my client really cannot afford to pay your full fee. Are you willing to reduce your fee? And I've done it without hesitation on many occasions.
Okay, thank you. I also intended to ask you about your involvement in the police advocacy training and offering support to junior advocates. Maybe you have covered it, unless you have something that we left out at the time when you refer to it.
I think I've covered that, Deputy Judge President.
Okay, thank you, DCJ.
Thank you, AJP. Acting Premier?
Thank you very much, DCJ. Good evening,
Good evening,
Advocate Bezuidenhout. The question I wanted to ask you was in relation to the briefing of junior advocates, but I think you have actually spoken to that, so I'm not going to ask. I'll just ask, I think having listened to what you are telling us now, it's also clear then that you are exposed to the fact that black attorneys and black advocates don't get briefed as a white attorney or a white advocate would be briefed.
No,
in other words, the briefing patterns are quite skewed. Now, what would you think should happen, or what do you think we should be doing to change that situation?
Commissioner, you know, over the last, I don't know how many years, it's come up time and again that approaches must be made to big commercial attorneys firms to change their briefing patterns. I can see there's a difference, but there's still a long way to go because it's one thing briefing, and I've used the term loosely, a baby junior. I know some people don't like that term, but for me a baby junior is someone between 0 and 5 years. And you see they get briefed in motion court maybe to do pretty straightforward matters, and it's from a big firm, and you can see that trying to change their briefing pattern. But from there, the next jump is to brief that same advocate maybe to do an opposed motion, where they can earn a much bigger fee. Yes, it's a bigger responsibility because they've got to come and argue the matter or brief them for a trial, but I don't see that jump. They tend to brief them for the more simple things so that they can make a tick and say, yes, I've briefed a young black female, but then they don't progress and take it further and allow that practitioner to now develop their skills and maybe give them the responsibility of a post-motion and let them work their way up. And we can always try. I mean, I know the LPC makes lots of inroads in approaching the attorneys' firms, and there's been lots of work done in that regard.
So do you think senior counsels like yourself would have a role in assisting to change this particular briefing patterns?
Well, we already, almost as a matter of course, either bring in juniors as deviling juniors or try and convince the attorney to speak to the client to bring in a junior and pay for that junior full fee, not the deviling fee. But we can only do so much. It starts with the attorney who's got the duty to instruct. I mean, I can't instruct a junior, the attorney must instruct the junior. I can only try and motivate as much as I can, and usually we're successful, but you also want those junior advocates to be given a chance on their own, to start building their practice and do their cases on their own, and not always live in the shadow of someone else.
Thank you, DCJ.
DCJ,
Yes, Commissioner Malema?
I'm worried where I'm warned about load shedding, so I thought I must ask my one question.
Yes, please go ahead.
Advocate, I'm on virtual. So I just want to ask, by appointing you as a female, not just a female, but also a white female, will we be in line with the requirements of the Constitution and in line with the transformative agenda that we want to carry out in the judiciary?
Commissioner, I think so, yes, for certain, because, well, firstly, appointing me as a woman in the Pietermaritzburg bench, there's, I think, 10 males and only 2 women at the moment. So if I'm appointed, then I'll be the 3rd woman. There's no white females on the Pietermaritzburg bench. So in that instance, I think, yes, it will definitely contribute.
Thank you very much. Thank you, DCJ.
Thank you, Commissioner Malema. Commissioner Prof?
Thank you very much, Deputy Chief Justice. Good afternoon, Judge.
I think it's good evening, but yes, good evening.
It's not even yet 6, so I think it's...
Yeah, it's early afternoon. Good
All right.
afternoon.
I heard you correctly that you said that amongst others, your speciality is family law.
Yes, I've done a lot of, I won't call myself a specialist, but I've done a lot of that type of work, a lot of divorces and what comes with it, yes.
I see that you also wrote a judgment, JVS versus LVS, that dealt with the Children's Act. The issue there was a parental plan. You don't remember it? Okay, no, that's fine. Let me ask you a question generally, because the thing is, I've been waiting for somebody who really understands family law, because there's an issue that I really want to converse. There is this view that Section 28, subsection 2 of the Constitution, that deals with the best interest of the child, and of course, that is given effect to, among others, by Section 7 of the Children's Act. And we know that the best interest of the child is paramount, right? But it appears to me that the word paramount has been used as this hammer, that everything else that conflict with the so-called best interest of the child, they play a second role. I just want to understand from you. I'm not sure if you are aware of the concept of relational autonomy. Okay, no, let me ask generally then. How do we balance the best interest of the child, having regard to the interests and the rights of other family members in a home situation? How do we balance that? Are the best interests of the children always going to trump over all other members?
Commissioner, thank you for that question. The best interest of a minor child is a tricky horse to ride because it literally depends from case to case. I think one of the factors that one takes into account when one considers the interest of minor children is also the bonds with extended family matters and extended family members. And quite often you find that, for instance, the aunts and the uncles and the grandparents have also got a lot of input in the raising of that child. And when the two parents start fighting and the poor child is in the middle, and then it becomes, the families also become involved, and then you've got to consider their interest as well. And suddenly where you previously just focused on the child and the mother and the father, you've got the aunts and the aunties and the grannies and the grandpas that also enter the fray. And you've got to give consideration to all the parties. It's not, you can't just ignore common sense and just focus on what's in the interest of the child per se. You can't see it in isolation, and that's why it sometimes becomes very difficult, because you can't follow a set set of rules. You can't just look at what the Act says and just look at those few factors. You've literally got to look at each case, look carefully at the facts, look at the extended relationships, and then try and make a decision. Sometimes it's difficult, like Solomon's wisdom. You can't, unfortunately, sometimes you've got to make very difficult decisions, but you've got to take so much, you've got to go so much wider than just the child and the mother and the father.
No, thank you very much. Thank you very much, Deputy Chief Justice.
Thank you, Commissioner Norumarufai. Any questions from the virtual platform? No.
Just one question, Jay, if I may.
Yes, Commissioner Singh.
Yeah, thank you very much. Good evening, Advocate Bezuidenhout.
Good evening, Commissioner.
I think the open door policy that you spoke about has really been confirmed by one of the law bodies where they speak. They wax lyrical about the open door policy and, non-racialism, et cetera, So well done on that. My one question, I think I asked you this the last time about traditional courts. Now that the traditional courts bill has gone through the National Assembly and received support, have you done a bit more reading in terms of traditional courts and since April?
Commissioner, I looked through the bill and on the face of it, it looks good, but lots of pieces of legislation looks good on the face of it. I asked one of the researchers at the High Court, and maybe it's a bit naughty to ask her because it wasn't really strictly to do with my work as a judge, but I asked her to just also get the comments of what was said when the bill passed through. I think not Parliament, one of the sessions when it was in Parliament. So I read the comments made by various parties when the bill was being discussed, and concerns were raised by certain parties, and time will tell whether the bill lives up to what is being promised, and I'm interested to see what's going to happen in the future. But it's definitely, it looks good on paper.
Thank you very much. I'm glad that you took interest and time in the last 6 months to look at it more closely. And perhaps this could be a red letter day for KwaZulu-Natal in terms of the judiciary, because if you are appointed, as you said, you'll be the first female from the bar in Pietermaritzburg. So I wish you luck. Thank you very much.
Thank you.
Thank you, DCJ.
President Betze.
Thank you, DCJ. Good evening, Advocate Bezuidenhout.
Good evening, Commissioner.
I'm looking at one of your judgments, some Roy May versus the state.
Yes.
It commences at page 91.
Commissioner, maybe you can just, I'm just trying to find my place here. I'm almost with you. Commissioner, maybe you can just refer me to the paragraph in the judgment, because I've got my bundle of documents in front of me. Well, I don't want to cause any delays.
Okay, thank you. It was an appeal against conviction and sentence.
That's correct.
And you dismissed the appeal against conviction, upheld the appeal in relation to sentence.
That's correct.
And paragraph 2 of your order then reads, the appellant's appeal against his sentence is upheld. The sentence is amended to read, then the appellant is sentenced to 25 years imprisonment.
Yes.
When you uphold an appeal against sentence, aren't you supposed to set aside the sentence and then substitute it with whatever sentence you consider appropriate?
Commissioner, I seem to recall that I had a debate with the judge that was sitting with me on the appeal, And I know we made a last-minute change, and it might be that that's what it read, and then we changed it. But I take your comment. I seem to recall, because I remember it was literally either the day before or the morning before judgment was handed down that we made a change to the order, and it might have been a change in the wrong direction. But I take your point.
If you are recommended for appointment or invited to act again, that's something that you should bear in mind. You set aside the sentence and substitute it with the fresh sentence.
Yes, no, definitely. Thank you for that, Commissioner. I really appreciate it. Thank you.
Thank you. Thank you, Mr. Chair.
Thank you, President. There are no more questions for you, Advocate Bezuidenhout. Okay. You're excused. Thank you.
Thank you so much.